Nick spoke 6 years, 5, 6 years now before COVID.
Yes.
And he came and spoke to us at Regents in London. The subject of expert witness doesn't go away. I think it probably gets more and more complicated as the legal system seems to get more and more complicated. So an update is long overdue. A number of the guys in the room do get involved in expert witness, but I suspect there's others. And we've got an audience online as well, of course, who perhaps this is new to. They can't see that. I don't know what to do.
You promised to.
I did promise another technical bridge. I honestly have no idea what to do. I don't know. I'm going to let Nick go on, otherwise. Yeah. I can try again if you like. I can. Stop the share. Oh, you can see that now? How bizarre. Okay.
This is why when I ran training pre-COVID, I always used a flip chart and pens. Never even got as far as I'd feel at home over there. I never got even as far as PowerPoint. So COVID and then running training online was an unholy leap into the 21st century, which nearly did away with me. So look, folks, I just wanted to give a brief introduction to what this is all about. So I used to be a barrister. I left all of that a long time ago to go into the training world. And I've been with Bond Solon now for just over 20 years. And I now head up the expert witness training wing of what Bond Solon does. And in the course of my practice as a barrister, I did some fairly low-level crime in court, and family work and personal injury work, and met and worked with some experts. Working with Bond Solon, I've met and worked with probably hundreds of experts across different fields. And as Mike was saying, I've spoken to this organisation probably about 5 or 6 years ago now. What I'm going to have a look at is 6 areas. So we're going to think about the role of the expert witness. What actually are you as an expert witness? We'll think about the duty of the expert witness. We'll think about what the work involves. Also, why do it? Which you may reflect on while you're doing it. Why did I sign up for this? And then think about the pitfalls, because there are plenty. And then some top tips at the end. So my aim is to bring this in no later than 12:35, which is then being on to the next speaker. So there we are. I've laid my cards out on the table. That is one manifesto promise that will not be broken. There we go. That's even worse, isn't it? So what is the role of the expert witness? Quick show of hands around the room. Who's given acted as an expert witness in the room? So some of you, oh great, excellent, thank you. If you've worked in the courts or if you've worked in international arbitration, you are probably aware that the law loves to define things, loves to give very precise definitions. And if you're looking for a definition of an expert witness, you'd probably go to the civil procedure rules in part 35, which talks about the expert witness work. But when you go there looking for a definition of an expert witness, you'd be rather disappointed, because when it comes to defining an expert witness, it says the following, and I quote, a reference to an expert witness is a reference to a witness who gives expert evidence. As definitions go, it is, well, it's right up there as a political promise, isn't it? It's completely pointless and tells us nothing at all. So we go back to what the judges say about expert witnesses. And what I thought I'd do is just give you the definition first, then very briefly explain why that's the definition. So the definition is up there. And the expert provides the court with special knowledge in a particular field. Special knowledge in a particular field. Well, how is that? How do they arrive at that thought, and what does that mean in practice? For the parties to a dispute to be allowed to use expert evidence, the court has to have given its permission. So a party can't just rock up and say, we've got an expert or 5 experts. The judge has to have given permission for them to do that. In order for the judge to determine that they are going to give permission, the judges have to satisfy the test that expert evidence is going to be reasonably necessary. What does that mean? How the judges interpret that is by asking themselves this question: will I be able to reach a sound decision on this case without the help of someone with special knowledge in a particular field? In other words, can I do this on my own? And there are plenty of cases where the judge says, I don't need an expert. This is just interpretation of facts. I've got it. We don't need anybody else. But there are occasions where the judges look at the evidence and say, well, no, I can look at this and just see a heap of numbers or a heap of pictures or something. I can't interpret this. And that's where they will grant the parties both probably permission to use an expert evidence and an expert witness. In other words, they'll say to themselves, I can't do this without specialist input. And that's where you come in. Does that make sense? So any Liam Neeson fans in the room? Any fans of Taken? This is your particular set of skills. Sometimes it works, it doesn't always, but there are. And it's critical to remember this, because this also feeds into the next step of why you're there and the duties. So first of all, just staying with this to start with, your special knowledge in a particular field. For an expert witness, you need to be very precise about defining your area of expertise. For your own sake, for the lawyers, for the judge, for the arbitration panel, but actually principally for your own sake. Because you will be instructed by firms of solicitors who think they know what you do because it's something to do with the sea, and they've got a case that is at sea, so they think you're the man for it, or you're the woman for it. But you may not be the right person, because the specific area may not be the area that they actually need. So there's a large part of your role which is going to educate the instructing solicitors. No, you don't need a me, you need a them. Does that make sense? So be very, very clear about your area of expertise. There are plenty of lawyers, obviously, and you'll have come across these, who specialize in the Admiralty Court, in maritime law and so on, but who still don't know some of the differences and distinctions. And they are, in a sense, are the most dangerous ones, because they think they know but don't. You need to be able to educate them. So be very clear what your particular field is, and then be able to demonstrate what your particular knowledge is in that. So that it consists of qualifications and it consists of experience. And one thing I do a lot in working with expert witnesses is get them to express their qualifications and experience in their reports and verbally in court practices in a way that's going to communicate to the judge. In other words, say to the judge, to the arbitrator, I can help you because of this. I don't know how big your CVs are looking currently. Probably there's a lot on there. When you're attaching a CV to the court report, it needs to be a distilled version, really answering the question for the judge, why I can help you, how I can help you. My suggestion is always no more than a page or 2 pages. I don't know if that gives anybody shocks around the room. But up until about 1.5 years ago, my running favourite, brackets not favourite, was a CV that an expert had submitted that lasted for 14 pages. I thought, well, that's pointless. No one's going to read beyond about page 2 of that. So if you haven't satisfied the judge as to your expertise by page 2, they're not going to stick with you to page 14 to give you the benefit of the doubt. That was overtaken phenomenally by an expert who provided 72 pages. And I thought, well, as an exercise in trumpet blowing, it's right up there with the brass bands combined of the entire United Kingdom. As an exercise in usefulness, it doesn't even get off the ground. So 72 pages, no. If you can distill that to one page without just reducing the font size, so much the better. So you could be instructed by either side, claimant or defendant, i.e. the person making the claim or the person defending the claim in civil claims and arbitrations. Let's shift it on. Legal obligations. This is the bit that undoes experts all the time. And I'm seeing a few nods around the room. You must have seen others sort of sinking under the weight of all of this. It's incredibly simple. It's not complex, and therefore, by definition, it's easy to mess it up. But the key component of this is in CPR 35, Civil Procedure Rules 35, which an expert witness in the civil court must know. And actually, a large part of this came from a definition from the Icarian Reefer, an Admiralty case back in 1993, where Mr. Justice Cresswell set out some essential principles for expert witnesses. So you can hold your heads high, knowing that the definitions and duties of the expert witness originated in an encapsulated form in an Admiralty case, the Icarian Reefer. As a Judge Riley noted in another case, he said the principles in the Icarian Reefer may well have been the sound of a ship passing in the night, as far as this current expert is concerned, who hadn't got hold of them at all. So the duty is to help the court on matters within your expertise by giving independent expert evidence, and that duty overrides obligations that you owe to the party instructing you or to the party from whom you're receiving payment. That's all it means. And that obligation kicks in from the moment you receive instructions. It doesn't happen when you arrive at court. It arrives when you receive those instructions to act as an expert witness. Everything you do after that has to be in line with this duty to help the court. So what does this actually mean? So you're there to help the court. In other words, you're not producing your report to help your instructing party. And that's the bit that your instructing party hates, that your instructing solicitor will try not to tell you, and that most experts find themselves, I suppose, subconsciously allying with the party instructing, because you naturally would do. One way of combating this is to ask yourself the question as you're writing the report, okay, so I'm instructed by the claimant in this case, and I'm writing this. Would I write exactly the same thing if I'd been instructed by the defendant? And if I wouldn't, then I need to delete what I'm trying to write and write something different. So you're probably going down a route of a more balanced, more nuanced range of options, rather than it is definitely this. Unless in your view it is definitely this. But what it means is you go down an evidence route, not an outcome route. And there was an expert witness criticizing this. This happens several times a year. But there was one that came across a few years ago where the expert was criticized by the judge. And the judge said, it seems to me that this expert has tried to make the evidence fit his opinion rather than make his opinion fit the evidence. And that's a really clear discipline to go down. I thought Peter's talk about the evidence levels that you're going through on a survey as opposed to a tick box, that absolutely chimes with the work in court. So right, yeah, steering, yes. Well, where's the evidence of that? Well, there's a tick in a box. Well, what's that? That's nothing. It works. Okay, how do you know that? Well, they told me. Or the people who want it to work, yes. Right, did you check it? Well, no. Why not? Well, because they told me. Anybody seen any part of the Horizon IT inquiry going on? What was your evidence that the system worked? Oh, well, the lawyers told me it worked. Oh, like a lawyer would know when an IT system works. Oh, and maybe I should have asked some more questions. Oh, you think? As CEO of an organization, you should have asked some more questions about, does this IT system actually work? It's extraordinary. And now it's all coming home to roost. But the principle's the same, isn't it? It's back down to the evidence. The courts are interested in the evidence. What's the evidence base? Does the evidence support the opinion? If it does, the courts will follow that route. If the evidence doesn't support the opinion, then they won't follow that route. And worse, they will start to have question marks about that expert witness. There was one back in 2017 who not only was making the evidence fit his opinion, but where there wasn't evidence, he actually decided to invent some. Whoever thought that was a good idea, I don't know. The judge certainly didn't. What does the work involve? So a very quick overview. So instructions from solicitor or client, you may very well find instructions coming through from the client first and then from solicitor. What do you then do? So there may be documents to analyze, records to have a look through and so on, vessel cargo to inspect, damage to the harbour, to the port to look at, and so on and so on and so on. Structures to examine, equipment to examine, and so on. And then write a court report. We were hearing earlier on, again, from Peter about the different styles of report that you might write it as you wear different hats in your roles. Your report as an expert witness is different again. And it's predominantly different in purpose, and therefore has to be different in structure and language as well. Because in producing a report that could be used in court, you are now addressing somebody who isn't you. And by that, I don't just mean a different person. I mean somebody who has never done what you do, somebody who doesn't have your experience, your knowledge, your expertise, the knowledge that you have, where you can step on board a vessel and you think, well, that looks wrong. That's never going to work. I need to examine this. A judge would step on board the vessel and go, right, I'm here. So what? You were talking earlier on about the steering and does it work? You might look at it, you might examine it and see something that triggers an alarm bell in your mind. A judge might look at that and say, okay, I see a round thing and two sticking out bits. Now, I'm not saying, do you know what I mean? They need to understand the significance of what you're describing. So think about that in your report. One of the things I always encourage experts to do in their written material is remember that you're not addressing a specialist. The Admiralty Court judges do predominantly work within the Admiralty Court, and so on, that's absolutely fine. But they probably haven't ever done what you do. So in talking about your areas of expertise, you need to be able to translate that and communicate it to the non-expert. It's a real skill to get hold of. And you might be asked for clarifications and amendments. This is where the alarm bells should really go off. When you provide your instructing solicitor with the report and they say, thank you very much, that's wonderful. Just a couple of things we'd like to clarify with you. Can you make a couple of amendments to your report? Could you just say this? Could you just say that? Be very, very careful with that. Of all the people you will meet in your careers as expert witnesses, the ones who are the most likely to get you to do the wrong thing are your own instructing solicitors. Through malice, because they want to win the case, through dim-wittedness, because they have got their eye off the ball, through forgetting that your role is independent, or sometimes simply because they've got enormous pressure from their client to win, and they're trying quite logically and quite really their best to win the case. but they can't pass that pressure on to you. And they do all the time. So you as experts need to be very firm at standing your ground and saying, no, I understand the problems with this, but that is a problem and I can't say any different. So you've got to stand firm on your view. You might get written questions from the other side. You will very likely get involved in discussions with the expert on the other side. Quick show of hands, who's been involved in discussions with the expert instructed by the other party? Again, some of you have, fine. There's quite a lot of case law developing about this, where things are going horribly wrong, not actually in the course of the discussion, because that typically depends on the rationality of your opposite number. And if you've got a rational opposite number, you're going to have a good discussion. If you've got one that's slightly nuts or slightly not taking their duties correctly, it's going to be a difficult discussion. The problem comes in the joint statement, in drafting the joint statement. And the problem in the drafting of the joint statement is the solicitor. There are lots of cases, and there was one 2 weeks ago, where the solicitor had been sent drafts of the joint statement by the expert witness and had made amendments to it, suggested amendments to their own expert, who'd taken them on board and made them. And the other side became aware of this. And the solicitors initially were saying, no, we've done nothing wrong at all. But like parties in Downing Street, nothing to see here. And eventually it was dragged out and, well, no, actually, yes, we did suggest amendments because we thought that they ought to be more in line with the pleaded case. We thought we were allowed to do that. On reflection, we realized that we're not allowed to do that. This is the lawyers. Who might you expect to understand and know the law in the whole process? It would be reasonable to hope that if the lawyer is asking you to do something, the lawyer's got it right. I would suggest you can't do that. So the discussions bit is a really hot topic of things going wrong. And then, of course, the final bit is giving evidence live. Why do it? So additional source of income, ish. Most people make the same expression. Actually, it's not a big money earner, and I get very suspicious of experts who say it is, and in the sense of worrying about how they're going to make it all work. It is certainly interesting. It is certainly challenging work, and it certainly informs your own practice. And makes you reflect on what you do. So I think for those reasons, yes, it is highly worth doing. And without a doubt, the industry needs you to be able to perform that role because the courts, the arbitration panels need your assistance. Pitfalls, not knowing or fulfilling your duty. The case law is littered with experts who have got this wrong, either through not really understanding it, not really applying it, or fundamentally, utterly ignoring it. There was an expert witness who's being cross-examined, and he said, under cross-examination, judge in court, the expert witness said, I see it as my duty to paint my client's case in the best possible light. The judge disagreed, and who wins? And the result of that was that the judge said, well, in that case, I'm going to disregard all of your evidence, the entirety of your report, and everything you've just said. Thank you and good night. So that was the end of him. Straying outside your area of expertise, be really clear what your area is, and then don't stray into other territory. This is, or should be, relatively straightforward for territory which is way outside of yours. Although it didn't stop a pathologist back in 2003 commenting on statistical evidence. it is more difficult when you've got your area of expertise and there are some sort of satellite areas that are very close to it that you know a lot about because of your expertise, but actually strictly that isn't within your expertise. And I don't know if that sort of makes sense in your different areas of practice. Those are the really dangerous bits where you're thinking, well, I could comment on that. Don't. If you're not holding it out as an area of expertise, of current practice, of current up-to-date work, don't hold yourself out as an expert. And then always the biggest pitfall is unquestionably doing what your lawyers ask you to do. Now, the problem with this is that if the expert doesn't know what their duty means and all the ins and outs of it, it's more difficult to push back. Over the years, I get probably on average 2 queries a week from expert witnesses who've been on Bond Solon courses and are saying, I've just had this request from the solicitor. I'm not sure, it doesn't feel right to me. Should I be doing this or not? Every single time, the expert witness has been right. But they just need that additional voice just to think, am I doing the right thing here? And it's the lawyer who's asking them to do the wrong thing. So a couple of thoughts. Get trained. Now, of course, I'd say that, wouldn't I? I run the expert witness training wing of Bond Solon. So here we are. Here's a selection of courses and a used watch. But it is absolutely vital to get training in producing material for the courts. A couple of bits I would recommend, particularly if you are interested, have a look on the Bond Solon website. There is a 10% discount on any course that is booked before the end of June, and there's a course code provided there. So have a look at the courses there. A couple I'd really recommend. If you're relatively new into expert witness work, I'd look at the report writing as an entry point. If you've been doing expert witness work already, I'd recommend doing the refresher in report writing. It's a small group of 5-6 delegates, and we work through each individual report, sort of section by section. It's a really useful way of getting to grips with the report again, refreshing your thinking about it, and so on. Have a look also at the courtroom skills day. If anybody's got any evidence giving cases coming up, you're going to give evidence in court, have a look at our courtroom skills work. It just gives you a practice in how to give evidence and so on. Do have a look at the discussions between experts work as well. There's quite a lot of useful stuff there about how to prepare, how to run it, how to do the draft joint statement and so on. And again, how to manage the solicitor. There's a large degree of that you need to be aware of. If you're looking at something more detailed, which will encapsulate most of those, there are 2 university accredited programs, the Cardiff one and the Aberdeen one. I think, Peter, you're saying you did the Cardiff one a while back. Aberdeen is if you're going to give evidence in the Scottish system, because their system is different and their what they call things is different in Scotland. So every law area has its different ways. So those are some thoughts about how to get trained. Overall thoughts, though: know your area of expertise and stay inside it. Know your duty to the court and fulfill it. And obviously watch out for experts who don't know it and don't fulfill it, and make a note to self, don't do that. And the final thing I'd say is just keep meticulous records. You do this anyway in your surveying role. Do this as well in your work as an expert witness. Keep meticulous records. Keep the clock running when you start doing some expert witness work on a particular case, and just keep a really precise record of how long have I spent writing? How long have I spent traveling? How long have I spent surveying? How long have I spent taking the photographs, etc., etc., etc. And do also think about what my roommate in Chambers, when I used to be a barrister, used to call the bathtub factor. That was the bit where you're thinking about the case, but you're doing something else. Because you do process this stuff to think it through. So think about the bathtub factor or the walking the dog factor or the going sailing factor while I'm thinking about the case in the background, because all of that is relevant. It just builds that picture of how much time you're giving to the case. There we are, another manifesto pledge broken. It is now 12:37. Apologies. It's closer than any other political party will get, I'm sure. But there we are. If anybody's got any questions, do ask. But I'm also conscious of next speaker. I don't want to leave too far into time there as well.
Right, any questions?
Yeah, so Peter, I think there's a question. Yeah.
How much expert witness would you be expected during the year to be current as an expert witness?
So the courts wouldn't worry about how much expert witness work you're doing. They're interested in your actual practice area. So it's the doing the stuff bit, whatever the stuff is, they're more interested. And the courts don't mind if this is your first time as an expert witness, if it's once a year, if it's once every 2 years. An expert last year, he's been an expert witness 20 years. The last time he was in court was 10 years ago. So the expert witness currency isn't a problem. Currency in being updated as an expert witness, so training would be of interest, but actually being instructed, they're not worried about. Yeah. Solicitors might be more interested, but courts less so. Yeah. 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 Yes.
Do you ever have any case studies? I feel like doing mostly medical malpractice. I think I was secondary expert.
Yeah. Yes.
But very interesting. Good. The quality of the online wasn't so good. It was 2 years ago.
Right.
I just wondered if you have any specific content material in the brief.
We haven't. And again, that's something we need to look at. And to be fair, a lot of specific sectors have said, what about something specific for us? There's too many doctors. But it's sort of self-selection in a sense. But I'm doing the law update this year, so I will have a look.
You say London is the workplace.
Yeah, yeah. Right. Okay. Thank you. Thank you for that.
Thank you. Can you be an expert witness if you have collected the evidence?
Yes, you can. You can. The only issue is to think about the capacity in which you collected it. In other words, were you acting as the expert advisor at that point? And have you done anything that could compromise that sense of independence? So if the only thing I'd say then is, if you're going in gathering material, always clock that you might then be the expert witness and do everything as if you were the expert witness, and therefore give that sense of balance, independence, impartiality. You know, I was instructed by one side at this point, I had access to this and this and this. There's no difficulty in transitioning between the two. The key to it is being able to be completely transparent. And so everything that you do and know in the evidence gathering phase, you are completely transparent about having done and knowing when you operate as an expert witness. Does that make sense? If you can move between the two without any difficulty, that's absolutely fine. But if there's something that happened in the course of that evidence gathering bit, that maybe the lawyers are saying, well, I know you heard about this, But I think as expert witness, you don't want to mention that in your report, do you? That's the bit where you have to put your foot down and say, well, I've got to, or you need to instruct somebody else. Does that make sense? Okay.
Any other questions? Because Nick, go around the floor. See you again.